So, welcome to the today's session of the Bharatiya Sakshya Adhiniyam. So, in the previous encounter, we have completed the primary documents and we have discussed in detail regarding all the explanations of the primary documents, in which we have taken a view that the document itself is a primary evidence. So, second type of documentary evidence is the secondary evidence. So, in case the availability of the primary document is not there, then the secondary evidence can be used. So, दो प्रकार के दस्तावेज होते हैं. पहला प्राइमरी दस्तावेज, दूसरा सेकेंडरी दस्तावेज. सो प्राइमरी दस्तावेज हम पढ़ चुके हैं, तो आज सेकेंडरी एविडेंस पढ़ेंगे. सो फ्रॉम टुडे we will be starting with the secondary document, which is dealt under section 58 of the Bharatiya Sakshya Adhiniyam. So same as I've already discussed in the previous classes, that Bharatiya Sakshya Adhiniyam has given statutory recognition to the electronic records, as in case of primary documents. Explanation 4 to explanation 7 deals with the consideration of the electronic documents or e-records. Similarly, in case of secondary evidences, so we will be starting with the secondary evidence. So there are 8 list. There is a list of 8 headings under section 58, which is an exhaustive list. So these documents will be considered as secondary evidence of a particular document. So we will be discussing in detail one by one. So the first heading, that is dealing with the certified copies. Certified copies of a document. Who provides certified copy? It is the gazetted officer appointed by the government or by the appropriate authority, who provides the copy of a particular document which is already registered under his authority. So that we will be discussing under section 75 of this adhiniyam itself. So as of now, you can just keep one thing in your mind, that any certified copy given by the prescribed officer in a prescribed format, so that copy will be considered as a secondary document. ठीक है जी. सो कोई भी किसी प्रकार की नकल जो अपना पदाधिकारी जो सरकार के द्वारा निर्धारित है, वह अगर अपना नकल को अपने हस्ताक्षर करके या अपनी सील लगाकर दे, तो वह दस्तावेज सेकेंडरी एविडेंस होगा. For example, so there is a land revenue records. So when there is a transfer of a property, so there is a registration in the office of registrar or sub registrar. So after the registration, any person can move an application to the office of the registrar or sub registrar and can get the certified copy by paying the appropriate fees or any other requirement. So that certified copy given by the public officer under his signature or under his seal will be a secondary evidence of that registration. ठीक है जी. So moving to the second head, that is the copies made from the original by mechanical process, which in themselves ensure the accuracy of the copy. So by any mechanical process, so for example a photostat machine, when we make a copy of a original document by the help of a photostat machine, so that copy produced by the photostat machine will be a secondary evidence, because it is ensuring the accuracy of that particular document. So there will be no discrepancy in that document, because there is a technical machine, photostat, that is copying that document, which is ensuring the credibility of that document. So there are very minimum of few chances that there will be any discrepancy or any flaw if we compare that copy with the original document. So कोई भी नकल जो हम फोटोस्टैट मशीन से कॉपी करके किसी दस्तावेज का निकालते हैं तो वह नकल सेकेंडरी एविडेंस होगा, क्योंकि उसमें कोई भी खराबी या कोई भी अलग होने के चांसेस बहुत कम हैं, क्योंकि टेक्नोलॉजी पे हम भरोसा कर सकते हैं. सो आफ्टर दैट एंड कॉपीज कंपेयर्ड विद सच कॉपीज, और उसके बाद जो कॉपी उसने निकाली फोटोस्टैट मशीन ने, the copy produced by that photostat machine, if we make a copy from that photostat machine and compare with the that copy, then that copy will also be a secondary evidence. ठीक है जी. सो ये था हमारा सेकंड हेड. और तीसरा हेड है कॉपीज मेड फ्रॉम और कंपेयर्ड विद ओरिजिनल. सो ओरिजिनल से अगर कोई कॉपी बनाएंगे और उसका कंपैरिजन करेंगे, कंपैरिजन मीन्स टू इंश्योर द क्रेडिबिलिटी ऑफ अ डॉक्यूमेंट, सो दैट विल ऑल्सो बी अ सेकेंडरी एविडेंस. सो फोर्थ हेडिंग, any counterpart of a document which is not signed by any party, so that will be a secondary evidence, as we have discussed under the primary evidence under explanation 2. So any counterpart that we have discussed in detail, so if the party signs it, that will be a primary evidence in relation to that party, and the party which does not sign that counterpart, then it will be a secondary evidence in relation to that party. So this is the fourth heading, and after that we will be moving to the fifth heading, that is the oral account of the contents of a document given by some person who has himself seen it. So as a general rule, oral evidence cannot be given of a document that we have already studied, but there are some exceptions that we will be studying in coming classes. So any person who has seen, जिसने डॉक्यूमेंट को बनते हुए एग्जीक्यूट करते हुए देखा है अपनी आँखों से, तो वह उसका अकाउंट मीन्स अपना स्टेटमेंट दे के बता सकता है कि डॉक्यूमेंट में क्या है, और उसका कथन, द स्टेटमेंट गिवन बाय दैट पर्सन विल बी ऑफ सेकेंडरी नेचर, दैट विल नॉट बी अ प्राइमरी एविडेंस. सो इट विल बी एडमिसिबल, बट इट विल ओनली बी अ सेकेंडरी एविडेंस. So section under heading 6, 7, 8 are new headings that has been incorporated in this adenium, and they were not available under Indian Evidence Act. So heading 6, it deals with the oral admissions, and seventh one, it is the written admissions. So any party who admits regarding the document, whether he or she has executed that document or not, so that admission means any statement which can be electronic or it can be in written form or it can be oral, from which inference can be drawn in relation to relevant fact or fact in issue, that we have already studied in detail under section 15 of this adenium. So any admissions, any fact admitted by the party regarding the document will be of secondary nature. So last heading, eighth one, evidence of a person who has examined a document, the original of which consists of numerous accounts or other documents which cannot conveniently be examined in court, and who is skilled in the examination of such documents. So eighth heading deals with the voluminous document which is very large, the document which is having a lot of pages or lot of content. So that is a very large document, and it will be very difficult for the court to bring the document and examine the whole document. So any evidence given by the person who is a skilled person regarding the reading the voluminous document, so any statement given by that person will also be of secondary nature. So कोई भी दस्तावेज जो बहुत ही लंबा है और जिसका मापदंड बहुत बड़ा है, तो उसका उसका व्याख्या कोई ऐसा व्यक्ति देता है कि जिसने उसका परीक्षण किया है और उसको उसका परीक्षण करने में उसमें कोई कला है, तो उसका साक्ष्य गौण साक्ष्य कहलाएगा. मीन्स द एविडेंस गिवन बाय दैट पर्सन regarding the examination of that voluminous document will be of secondary nature. So ठीक है जी. So these were the 8 headings under which the secondary evidence of a person will be considered under section 58 of the Adhiniyam. So these were the 8 headings. So after that, section 59 deals with the golden rule. Golden rule means documents shall be proved by primary evidence except cases herein mentioned. So as a general rule, so any document which needs to be proved in the court will be proved by the primary document. So if the availability of primary evidence is not there, so that we will be discussing under section 60 where secondary evidence comes into play. But as of a general rule, the documents will always be proved by primary evidence. So this is the golden rule of Bharatiya Sakshya Adhiniyam. Keep this thing in your mind. If 2 documents are available, one is the primary document and the second one is the secondary document of the same document. First one is primary evidence and second is secondary evidence. So in that situation, only primary evidence will be admissible and the secondary evidence will not be admissible at that point of time because of section 59, because there is a preference given to the primary evidence over the secondary evidence in relation to proving the documents. So उसके बाद हम पढ़ेंगे कौन कौन सी परिस्थितियों में गौण साक्ष्य, किसी दस्तावेज का गौण साक्ष्य अदालत के सामने प्रस्तुत किया जा सकता है साक्ष्य के रूप में. सो सेक्शन 60 डील्स विद दी दोज कंडीशंस इन विच secondary evidence is coming into play. So in that we will be discussing 7 situations under which the secondary evidence can be used in relation to prove a document. So those 7 situations we will be covering in our next session. So as of now, the section 58 is very important because in case of your preliminary exams, be it of judiciary or any other competitive exam, it comes very handy in your exams. So you have to learn all these 8 situations. What are the 8 headings of the secondary evidence, and along with that you have to read illustrations in details to get knowledge in depth. So ठीक है जी. So आपको section 58 को अच्छे तरीके से पढ़ना है and after that you have to study the best evidence rule under section 59 that we have discussed in detail. So after today, so in tomorrow's session we will be discussing those 7 situations when secondary evidence comes into play because of the conditions as prescribed by section 60. So that's all for today. So we have covered the secondary evidence headings. So tomorrow we will be starting with section 60. Thanks a lot.